Law, a seemingly simple word, yet it governs our lives, shapes our societies, and provides a framework for resolving disputes. But what exactly is law? Where does it come from? And what makes it binding? These fundamental questions have puzzled thinkers for centuries, giving rise to the field of jurisprudence, the philosophy of law. Jurisprudence delves into the nature, purpose, and underlying principles of legal systems. It's not about memorizing statutes or analyzing case law, but rather about critically examining the very foundations upon which our legal structures rest. Why should we care about such abstract philosophical inquiries? Because understanding the different schools of thought within jurisprudence can illuminate our understanding of law itself. It allows us to engage in more nuanced discussions about legal issues, to critically analyze existing laws, and to advocate for legal reform. By grasping the historical development and theoretical underpinnings of legal principles, we equip ourselves to be more informed citizens, lawyers, and policymakers. This essay takes a journey through the fascinating landscape of jurisprudence. It explores some of the most influential schools of thought that have shaped our understanding of law. From the ancient wisdom of natural law to the critical lens of feminist jurisprudence, each theory offers a unique perspective on the nature and function of law in society. By understanding these diverse perspectives, we can gain a richer appreciation for the complexities of law and its profound impact on our lives. At the heart of natural law theory lies the belief in a higher moral order that transcends human-made laws. It posits that there are universal and immutable principles of justice and right conduct, accessible through reason and inherent in the nature of human beings. These principles, natural law theorists argue, form the foundation upon which all just laws must be based. Aristotle, the Greek philosopher, articulated an early version of natural law, suggesting that there's a natural order to the world, and law should reflect this order. Thomas Aquinas, a prominent figure in medieval philosophy, further developed this theory, arguing that natural law is derived from God's eternal law and is accessible through human reason. He believed that unjust laws, those that contradict natural laws, are not truly laws at all and lack moral authority. John Locke, a key figure in the Enlightenment, linked natural law to individual rights. He argued that humans possess inherent rights to life, liberty, and property, which predate government and cannot be infringed upon. Locke's ideas heavily influenced the American Declaration of Independence, which proclaims that all men are endowed with certain unalienable rights. Despite its enduring appeal, natural law theory has faced criticism. Critics argue that the concept of universal moral order is subjective and varies across cultures and time periods. They question the source and objectivity of these higher principles, suggesting that they often reflect the biases and values of the societies from which they emerge. However, natural law theory's emphasis on justice, morality, and the inherent dignity of individuals continues to resonate in contemporary legal and political discourse. In contrast to natural law theory's focus on morality, legal positivism emphasizes the conventional nature of law. This school of thought separates law from morality, arguing that the existence and validity of law depend not on its inherent justice, but on its source and form. According to legal positivists, law is what has been created and recognized as such through established procedures within a given society. John Austin, a prominent 19th century legal theorist, articulated a command theory of law. He argued that law is essentially a command issued by a sovereign, a person or body who is habitually obeyed, and backed by the threat of punishment. While Austin's theory provided a clear and simple explanation of legal authority, it struggled to account for laws that confer rights or regulate power, rather than simply commanding obedience. H.L.A. Hart, a leading figure in 20th century jurisprudence, refined legal positivism by introducing the concept of rules of recognition. These rules, according to Hart, are social rules that determine how laws are created, identified and changed within a legal system. He argued that law is not just a set of commands but a complex system of primary and secondary rules, with secondary rules governing the creation and application of primary rules. Hans Kelsen, another influential legal positivist, developed the pure theory of law. He sought to create a science of law, free from moral or sociological considerations, focusing on the hierarchical structure of legal norms. Kelsen argued that all legal norms derive their validity from a Grundnorm, a basic norm that sits at the apex of the legal system and from which all other norms flow. Legal positivism, despite its clarity and emphasis on legal certainty, has been criticized for its potential to justify unjust laws. By separating law from morality, critics argue that legal positivism might legitimize oppressive regimes simply because they follow established legal procedures. However, its focus on the formal aspects of law, the importance of legal certainty, and the distinction between law and morality remain crucial contributions to our understanding of legal systems. While natural law theorists sought moral grounding and legal positivists focused on formal structures, legal realists emerged in the early 20th century with a more pragmatic approach. They shifted attention from abstract legal principles to the practical application of law in the real world. Legal realists argued that law is not a static set of rules but a dynamic process shaped by social context, judicial discretion, and the realities of legal practice. Oliver Wendell Holmes Jr., a renowned American jurist, famously stated that the life of the law has not been logic, it has been experience. He believed that law should be understood not through abstract reasoning, but by examining how it actually operates in society. Holmes emphasized the role of judges in shaping law, suggesting that they make decisions based not only on legal rules, but also on their personal experiences, values, and understanding of social needs. Carl Llewellyn, another prominent legal realist, emphasized the importance of studying law jobs, the actual tasks that law performs in society. He believed that to understand law, one must look beyond legal doctrines and examine how law functions in specific contexts, such as contract law in business transactions or tort law in resolving accidents. Legal realism provided a valuable corrective to overly formalistic approaches to law, highlighting the role of judicial discretion and the social context of legal decision-making. However, critics argued that its emphasis on the unpredictability of law and the subjective nature of judicial decisions could undermine legal certainty and the rule of law. Despite these criticisms, legal realism's focus on the practical application of law and the influence of social factors on legal outcomes continues to shape legal scholarship and practice. Section 5. Historical School of Jurisprudence. The evolution of legal systems. The Historical School of Jurisprudence emerged in the 19th century, emphasizing the historical evolution of legal systems and the cultural specificity of law. Proponents of this school argued that law is not a product of abstract reason but a reflection of a nation's history, customs, and spirit. They believed that law develops organically over time, shaped by the shared experiences and values of a particular people. Friedrich Carl von Savigny, a leading figure in the historical school, rejected the idea of a universal natural law. He argued that each nation develops its own unique legal system, reflecting its particular historical circumstances and cultural identity. Savigny believed that law is found not in abstract principles but in the Volksgeist, the common consciousness or spirit of a people. According to Savigny, legal change should be gradual and evolutionary, reflecting the organic development of a nation's legal consciousness. He opposed attempts to impose abstract legal codes or principles from above, arguing that such efforts would fail to take root in the unique historical and cultural context of a nation. The historical school of jurisprudence provided valuable insights into the cultural and historical dimensions of law. It highlighted the importance of understanding the historical development of legal systems and the role of custom and tradition in shaping legal norms. However, critics argued that its emphasis on cultural specificity could be used to justify outdated or unjust laws by appealing to tradition. They also questioned whether the concept of a unified Volksgeist accurately reflects the diversity of views and experiences within a nation. Section 6. Sociological Jurisprudence. Law as a reflection of society. Sociological jurisprudence emerged in the late 19th and early 20th centuries, emphasizing the interplay between law and society. Proponents of this school argued that law is not an isolated system of rules, but an integral part of the social fabric, constantly interacting with and influenced by social forces, values, and changes. Roscoe Pound, a prominent figure in sociological jurisprudence, emphasized the social engineering function of law. He believed that law should be a tool for achieving social progress and resolving social problems. Pound argued that judges and lawmakers should consider the social consequences of legal decisions and strive to create laws that promote social harmony and well-being. Sociological jurisprudence encouraged a more empirical and interdisciplinary approach to legal scholarship. It urged legal scholars to draw on sociology, economics, psychology, and other social sciences to understand the social context of law and its impact on society. Critics of sociological jurisprudence argued that its focus on social engineering could lead to an instrumental view of law, where individual rights might be sacrificed for the sake of broader social goals. They also questioned whether law could effectively address complex social problems, given the limitations of legal institutions and the often contested nature of social values. Despite these criticisms, sociological jurisprudence's emphasis on the social context of law and its potential for social change continues to influence legal scholarship and policy debates. Section 7. Critical Legal Studies. Unmasking Power and Inequality. Emerging in the 1970s, critical legal studies, or CLS, challenged the traditional assumptions and neutrality of legal doctrine. CLS scholars, influenced by Marxist, postmodernist, and critical race theory perspectives, argued that law is not a neutral arbiter of disputes, but a tool for maintaining existing power structures and perpetuating social inequalities. Duncan Kennedy, a leading figure in CLS, argued that the legal reasoning is inherently indeterminate and that legal doctrines often mask underlying power relationships. He believed that law is characterized by contradictions and inconsistencies that reflect the competing interests and power dynamics within society. Roberto Unger, another influential CLS scholar, challenged the idea of a fixed legal order. He argued that legal principles and institutions are constantly evolving and that they should be subject to radical critique and transformation to achieve greater social justice. CLS scholars deconstructed legal doctrines, exposing the ways in which they often serve the interests of the powerful at the expense of the marginalized. They highlighted the role of law in perpetuating racial, gender, and economic inequalities, challenging the traditional view of law as a neutral and objective system. Critics of CLS argued that its emphasis on the indeterminacy of law and its deconstructive approach could undermine the legitimacy of legal institutions and lead to legal nihilism. They also questioned whether CLS offered practical solutions for achieving social justice, or if its primary contribution was limited to critique. Despite these criticisms, CLS's focus on power dynamics, social inequality, and the role of law in perpetuating injustice continues to challenge traditional legal thinking. Section 8. Feminist Jurisprudence Challenging Gender Bias in Law. Feminist jurisprudence emerged in the 1970s, drawing attention to the pervasive influence of gender in law and challenging the traditional male-dominated perspectives that shape legal doctrines and institutions. Feminist legal scholars argue that law has historically been constructed from a male point of view, reflecting and reinforcing patriarchal power structures and perpetuating gender inequality. Catherine MacKinnon, a prominent feminist legal theorist, argued that law itself is a mechanism of male dominance. She criticized the traditional liberal conception of equality, arguing that it fails to address the underlying power imbalances between men and women. MacKinnon advocated for a transformative approach to law that recognizes and addresses the systemic nature of gender inequality. Carol Gilligan, a psychologist and feminist scholar, challenged the traditional male-centric view of moral development. She argued that women often approach moral dilemmas differently than men, emphasizing care, relationships, and responsibility to others. Gilligan's work highlighted the need for a more inclusive legal system that recognizes and values diverse perspectives and experiences. Feminist jurisprudence has had a profound impact on legal scholarship and practice, leading to reforms in areas such as reproductive rights, domestic violence, sexual harassment, and employment discrimination. It has also contributed to a more nuanced understanding of concepts such as equality, justice, and fairness. Critics of feminist jurisprudence argue that its focus on gender essentialism, the idea that there are inherent differences between men and women, could reinforce gender stereotypes. They also question whether a separate feminist jurisprudence is necessary, or if gender equality can be achieved within existing legal frameworks. Section 9. Conclusion: the enduring relevance of jurisprudence. Our exploration of the philosophical schools of jurisprudence reveals a rich tapestry of ideas about the nature, purpose, and function of law in society. From the eternal quest for justice in natural law theory to the critical lens of feminist jurisprudence, each school of thought offers a unique perspective on the complexities of law and its relationship to morality, power, history, and social change. Jurisprudence matters because it provides us with the tools to critically examine the foundations of our legal systems and to engage in more nuanced and informed discussions about legal issues. By understanding the historical development, theoretical underpinnings, and strengths and weaknesses of different jurisprudential approaches, we can better evaluate the legitimacy and justness of legal rules and institutions. The study of jurisprudence is not merely an academic exercise, but an essential endeavor for anyone seeking to understand the role of law in shaping our lives and societies. By grappling with the fundamental questions about the nature of law, its relationship to morality, and its capacity for both justice and oppression, we equip ourselves to be more informed citizens, lawyers, policymakers, and advocates for a more just and equitable world. As we continue to grapple with complex legal and social issues, the insights of jurisprudence will remain invaluable in guiding our understanding of law's possibilities and limitations in the pursuit of a more just and equitable society.